Anything? It's very rare to get a court like this. So you could have taken up PILs.
We only hope this court sits regularly in one of the divisions, and we're looking forward for.
Let's hope so.
Let's hope someday.
Thank you.
I don't understand.
My Lord, item 7 is fixed for final hearing. For the sake of effective assistance, I have prepared a written argument also. It will be completed in the second half. If this matter can come up in the next week.
You are for the appellant.
My Lord.
On premier by the appellant. Matters adjourned. This is matter for 1 week.
Deeply obeyed.
May I please, Your Lordship? Your Lordship, I beg to mention item number 14, Your Lordship. I am for the petitioner, Your Lordship, here.
14, no?
If Your Lordship can have the matter after 1 week, Your Lordship, as we have just received the affidavit filed by the respondent, Your Lordship, so we have to
My
examine.
Lord, this matter was heard, and during the course of the hearing, Lord, there was a observation whether we have complied with the procedure, my Lord. This with regard to the compensation bill, my Lord, MECL matter. So we have filed, Lordship has directed us, my Lord, yes, under 10.5, I have made a statement, we have complied, but we did not file in the affidavit in opposition. So additional affidavit has been filed, my Lord.
Yeah,
We want to record that we have complied.
Would you like to file a rejoinder to it, or
We'll examine the affidavit, Your Lordship, and if required, we'll
you've got received it just recently
I have filed on Monday, my Lord.
on pre-made by the learned counsel for the petitioner, seeking time to file a response to the additional affidavit filed by the respondent MECL. Matter is adjourned. This is after 2 weeks.
deeply obliged, Your Lordship.
Please, Your Lordship. Lordship, I beg to mention item number 2 from supplementary list, Your Lordship.
Yes.
Lordship, I'm bringing 2 more weeks time, Your Lordship.
Foxo matter.
On pre-made by the petitioner. This is matter after 2 weeks by the petitioner. Fine.
Lordship, similar prayer for item 8 from daily list, Your Lordship. 8 and 16, Your Lordship.
19. 19. Okay.
Yes, Mr. Sengupta, you.
Yes, my lord. And for the state, my lord, along with Mr. H. Kharmi.
On pre-made by the appellant. Seeking adjournment in this matter on ground of personal difficulty of the counsel. That is adjourned. This is after 2 weeks.
Lordship, item 16, Your Lordship.
16 tomorrow.
Your Lordship.
What is this matter about?
Lord, this is against the conviction, my lord.
On pre-made by petitioner. This is matter after 2 weeks.
May it please your lordship. Lordship, I beg to make a mention of item number 13. Lordship, I'm praying if this matter may be listed after a week's time.
I'm appearing on behalf of the respondents, my lord.
On pre-made by petitioner, this is matter after 2 weeks.
Would you like
Lordship, a similar prayer for item number 9 and 10. Lordship, these are connected matters. 9 and 10, Lordship.
9 and 10. 9 and 10.
Lordship, Lordship, Mr. Thapa is currently out of station. I'm praying this matter may be listed after a week.
Prayer has been made seeking adjournment on the ground that the learned conducting counsel is out of station. On consideration of the same, prayer is allowed. This is matter to 2 weeks.
Highly obliged, Lordship.
9 and 10, same.
19.
Please, Your Lordship, I beg to mention item number 18, Lordship.
Yes. No objection. On prayer made by the appellant seeking adjournment in this matter, the same not be objected to by state respondent, matter is adjourned. This is seen after 3 weeks.
Highly obliged. Yeah, please, Your Lordship. Lordship, I beg to mention item number 15.
Therefore,
For the writ petitioner, Your Lordship.
petitioner,
Yes, Your Lordship.
15. Yes, Mr. Khan, you're here.
Lordship, I'm here.
What is this matter about?
Gradation is, Lordship. We have only had one submission
Service matter.
that waived it here.
Prayer has been made seeking adjournment on the ground that the learned conducting counsel is indisposed. The same not being objected to by respondent, pray allowed. This is matter to 2 weeks.
Oblige.
My lord, item 12 of the hearing list, my lord. Lord, this matter was actually, my lord, sent to Lok Adalat, my lord, and then it has come back. So, my lord, I'll pray for a week's time, my lord.
Actually, they were supposed to seek an instruction,
Yes,
my
my
lord.
lord. But because I had to give the files, hand over the files to the department, my lord. So I'll pray for a week's time.
What is this matter about?
This matter, my lord, the petitioner is before the Honorable Court so as to enable him to come under the purview of the old pension scheme, my lord.
My lord, this is that matter, my lord, the school teacher matter, where my lord will remember that he was appointed by the managing committee. My lord, at a later stage in the year 2019, our government has considered his appointment and regularized his service, my lord. That matter, my lord.
It's only with the time period.
Yes, my lord, that is the matter.
Whether he's eligible
All
from the date he
pension
was
scheme or the
appointed
NPS?
later.
Yes, my lord.
On prayer made by the respondent, state respondent, not objected to by petitioner. This is matter after 1 week.
My lord.
Lordship.
1 week.
I'll oblige, my lord.
On supplementary cost list, item number 1.
May I please, Your Lordship? Your Lordship, let this matter may come up next week, Your Lordship. As per the information of the client, they want to, the senior counsel will lead the matter.
Why? It's an application for continuation.
Yes, Your Lordship. But as per the information I received, they want it next week. Like some senior counsel will lead the matter, Your Lordship.
I could have allowed the petition. You wanted to delay the matter. Good. On prayer made by the petitioner, this is matter after 1 week.
Much obliged, Your Lordship.
On daily cost list, item number 1.
Well, this matter will take some time, so perhaps it can come after the other ones.
End of the boat.
End of the vote.
Yes.
Item number 2.
439 bail application. Today is fixed for case diary, Lordship. And we are behind the bar for 184 days to date, Lordship.
When Section 37 is involved,
Lordship.
when Section 37 of the NDPS Act is involved, see, period of incarceration is not
Lordship,
irrelevant.
so far in this case, Your Lordship, can you see its quantity, Your Lordship, is 72, almost 72 kgs of ganja, Your Lordship, has been seized, Your Lordship. So in this type of case, Your Lordship, in my humble and respectful submission, Your Lordship, jail should be the rule and bail is an exception.
What is the stage of the case?
We have
Lordship, tomorrow is the case is fixed for consideration of charge.
Consideration of charge.
Your Lordship, in commercial quantity, Lordship, he is enlarged on bail, Lordship, 180 days.
Because in this case, see,
Lordship,
look at this.
180 days.
Look at this line. It says submitted that the case that investigation is not yet completed.
In commercial quantity.
So even see, after 180 days.
180 days, Lordship.
If investigation is not completed, with meaning which when charge sheet has not been filed, then of course
Lordship.
you are entitled to default bail, irrespective of the offence.
Lordship.
But not here. Here, in this case, I don't think this is applicable.
Considering the length of detention, Lordship, and matter is search seated, Lordship.
How many accused are there?
2, Your Lordship.
2. Considering the length of detention, Lordship,
72
I may be
kgs
allowed
were
to
seized from the vehicle, Your Lordship.
any terms and
And
conditions.
who's the
We may be allowed, Lordship.
the accused is he a driver or is he a helper or is he
Lordship,
owner?
they are Lordship, in my humble and respectful submission, they are a supplier of peddler, Your Lordship.
Lordship.
Because they conceal in their vehicle, Your Lordship. Only when the vehicle was searched, Your Lordship, then
apart from that,
and we
Lordship,
took the help of the National Crime Bureau also, Your Lordship, to determine
apart
the.
from that, we may be considered, Lordship, imposing any terms and conditions by this honorable court. That is my humble submission before this.
Heard Leonard, Mr. Leonard, counsel for the petitioner. To accuse himself of the petitioner?
No, Your Lordship, somebody is, that has not been disclosed. How the bail applicant herein is related to the both the accused also have not been stated, Your Lordship.
Oh, for two accused person?
Lordship, yes. Relationship has not been disclosed, Your Lordship. Your Lordship, kindly come to page 10 of the affidavit sworn. Whether the bail applicant is their friend or related in one way or another way also, that has not been.
You have not stated here.
Nothing has been stated, Your Lordship.
Should have stated.
Kindly consider.
How is the petitioner related to the accused person? Whether he is their friend or he is their relative or.
That has not
uncle.
been disclosed, Your Lordship.
That has to be clear.
Lordship.
Room to go, counsel for the. Well submitted that the admitted fact is that the accused person for which the petitioner has filed his petition seeking grant of bail are in custody for about 180 days or so in connection with CRL NDPS under bracket NDPS case number 12 of 2023 pending before the Court of the Special Judge NDPS at Clariat East Gentile Hills District. The Learned Council has not urged on the merits of the case in spite of the fact that the charge sheet has already been filed before the concerned court, but has petitioned this court for grant of bail only on the ground that the accused persons have been incarcerated in custody for according to him, a very long period, that is 180 days. Mr. Ndishwai, London EAG, on the other hand, has submitted that the offence alleged is very serious, inasmuch as it involves seizure of about 72 kgs of ganja.
Lordship.
Is the word ganja used or marijuana? Cannabis. Ganja. Which is a banned contraband substance, psychotropic substance. It is also something that the rigors of section 37 of the NDPS Act will come into play in this case, as seizure of commercial quantity of the said contraband substance have been seized from the possession of the accused person. Accordingly, it is prayed that this petition is devoid of merit and the same is liable to be dismissed. Without going to the facts and circumstances of the case, on the basis of the submission made, this court is made to understand that the accused person namely so has been arrested in connection with the said NDPS case and are now facing trial. As far as the question of bail is concerned, the provision of section 37 would indeed, section 37 NDPS Act would indeed come into play, inasmuch as the provision thereof would be applicable to the case of the accused person herein. From the charge sheet and the materials on record, nothing is indicated that the court doubts the guilt of the accused person prima facie, and accordingly bail as a rule is not to be considered under such circumstances. Accordingly, at this juncture, this court is not inclined to allow the prayer made by the petitioner. Under changed circumstances, the petitioner may approach the competent court of jurisdiction for grant of bail. X. Petition is hereby dismissed as devoid of merit. Before parting, this court would request the trial court to expeditiously dispose of the matter for interest of justice, so as to ensure that the innocent, so as to ensure that ends of justice are met. Along to petition disposal. Petition disposal.
Obliged, Lord.
Thank you.
Item number 6.
May it please your lordship. Your lordship, and for respondents 1 to 5 KHDC, your lordship, in the last occasion we wanted to file an application regarding the maintainability. Your lordship, can it be done during the course of the day, your lordship? It's ready, your lordship, we just have to file it.
May it please your lordship.
Is it necessary to file?
It's necessary, your lordship.
Maintainability can be pleaded at any point of time.
Yes, your lordship, my senior wants it in writing, your lordship. It's already ready, your lordship, we're just going to file it today, your lordship.
May it please your lordship. On behalf of respondent number 7, also we would like to file a small petition, your lordship, objecting to the maintainability of the extended petition. I humbly pray before your lordship to kindly consider within 2 weeks' time, your lordship.
The last statement was they'd already entered appearance. They made no prayer for filing any affidavit questioning the maintainability. They can file a composite application on the merits as well as maintainability. As far as KHDC is concerned, they want to file an affidavit standalone on the issue of maintainability. In the course of they have no difficulty with that. As far as respondent number 6 and 7 is concerned, they can file a normal affidavit.
If you want to raise the issue of maintainability, your lordship, you may be considered, your lordship.
But if the issue of maintainability is concerned, is heard, you see, either, as regard the prayer made by the KHDC or other, it will still be heard.
Lord, no, what I'm saying is the KHDC is already raising it.
Yes, but it makes no difference if the other parties or the other respondents will make a separate application for that, or they file a composite counter affidavit when the issue of maintainability will eventually be heard first.
Okay.
So we'll leave it at that and take up the issue of maintainability on next date.
Okay. No, what I'm saying is they'll file it in the course of the day today. Let's say the matter is taken up this week or next week, but it'll be stalled because now the respondent number 7 wants to file it separately.
No, you do it, but definitely within the next date fix, the matter will be heard. If not, matter will be heard, because it makes no difference whether you file it or not. It makes no difference. Matter will be heard. So as Mr. Sen has said, so as not to stall the proceedings. So will you
file it before the next date? The matter.
Please do that. Ms. Sinokla, learned counsel for the respondent KHDC, has submitted that the said respondent may be allowed to file an affidavit for this court to hear on the issue of maintainability. Similarly, the respondent numbers, you are 6 or 7? 7. Respondent number 7 has also sought time to file an affidavit on the same issue, that is, as regard maintainability. The learned counsel for the petitioner has no objection to the prayer made, but has, however, urged that the issue of maintainability may be heard at the earliest. Accordingly, the prayer of the said respondents are allowed. The said affidavit is to be filed definitely within the next date fix. Advance copy to the petitioner will be supplied in the meantime. For response, if any, by the petitioner to be also filed within the next date fix. This is matter to 2 weeks.
Highly obliged.
You do that within 1 week or
Yes.
so. Then you can respond if you want to.
Highly obliged.
Item number 11.
May it please your lordship. The conducting counsel, Dr. N. Mozika, is on next before court number 4, your lordship.
So, end of the vote.
Yes, lordship.
So this matter can come up next week, my lord, because I have another matter in the court number 4. It's a fixed matter.
On prayer made by the parties, this is matter to 1 week.
Highly obliged.
Item number 17.
We are here, all of us are here. My friend may proceed.
Please.
Please, Your Lordship.
Yes, please.
Your Lordship, may I kindly have a look at the last order 38/2023.
Yes.
Paragraph 4, Your Lordship. Looking into the facts and circumstances of this case, the parties are in agreement that the issue may be taken up and decided at the earliest on the parties filing their respective pleadings. So now pleadings have been exchanged.
All
All.
respondents have filed. And you are not finding any rejoinder.
Because in my I file a rejoinder to the respondent number 5's affidavit, which will cover the district council affidavit also, and the respondent number 6. So now, Your Lordship, looking at the core issue of this case, my first submission is that whether these statutory provisions provided under the Act and rules have been followed or not before any proceeding starts. Your Lordship, prior to 2016, I was appointed as an acting chief. Thereafter, in 2014, there was a situation that I was removed and I had filed a writ petition before this court, and this court has stayed, and thereafter the order of suspension against me was revoked and elections were called. So I participated in the elections, in the elections whereby I was elected as a full-fledged CM. So since 2016, I had been functioning as a CM of Langrin. Thereafter, in 2018, at the fag end of the year, that is in December, I was again removed on the basis of some complaints. So I was out of office for 8 months. So after that, there was an inquiry conducted. Thereafter, I was reinstated again in the month of August. Since then, I've been functioning as the CM of Langrin. Now, what has come about in the instant case is that, Your Lordship, there has been a complaint against me by the respondent number 6. And that, Your Lordship, will find
Respondent number 6 is the
Singh Samla, Your Lordship,
You are respondent 6.
at Annexure 3, Your Lordship. Annexure 1 or 2 are my appointment orders, Your Lordship.
Page?
Annexure 3, page 38. This is the complaint dated 5/7/2023.
Yes.
Lordship, I will not dwell into the merits of the complaint. Why? Because my basic grievances before this court is, before going into the complaint, whether the statutory provisions have been complied or not. Now, Your Lordship, a complaint has been filed. Thereafter, I was asked to file my show cause. Prior to that, there was an order saying that I have a limitation to spend the accounts of the, there are some restriction that the maximum I can spend is 25,000 because of these complaints. Thereafter, they issued me a show cause notice, and I filed my show cause notice also. Your Lordship, that will file at
subsequent to the complaint.
yes. On 5/7/2023, I have filed my complaint and have made a specific pleading that I may be allowed to be heard in person or through an advocate.
Where is your?
That is Annexure 6, Lordship.
Page?
Page 92. I'll just read, Your Lordship.
This is your forwarding.
Writing reference to the subject cited above, I, the undersigned, beg to state I am on receipt of your letter dated 26/7/2023, whereby I have been directed to file my show cause to the complaint dated 5/7/3 within 7 days and to furnish a statement of accounts, funds of Langdon's aimship. It is stated herein that I, the undersigned, craves leave to fix a date to be heard in person or through an advocate after my show cause has been filed. In view of the above, today, the 31/7/2023, I am furnishing the statement of accounts, funds of Langdon's aimship, and my show cause to the complaint will be filed on or before 2/8 as contained in your letter dated 26/7/2023. Now, Your Lordship, I filed my show cause. I have denied the allegations. Again, I will not go into the merit because my primary contention is that whether the statutory provision has been followed or not. Thereafter, on receipt of my show cause notice, I was suspended. That is at Annexure 9, page 131. August 2023, this happens to be a Friday.
Yes.
This is to notify in an entire Langdon's aimship that since the Executive Committee of the Khasi Hills Autonomous Districts has suspended the functions of Sri Nangtai Singh Semyong as the CM of Langdon, as such as per powers conferred under Section 7 of the Khasi Hills Autonomous District Nomination and Election of CM, Deputy CM and Headman of Langdon's aimship Act 2007 is pleased to temporarily appoint Sri Brel Henry Semyong as acting CM of Langdon's aimship and to look after the affairs of the aimship. Now, this notification was served to me on 19th afternoon at my residence on Saturday. On receipt of this, we immediately approached this Honorable Court on 21st morning by an unlisted motion. And kindly enough, Your Lordship was pleased to grant some status quo order. Now, in this notification, it does not even specify whether there is an order of suspension pending inquiry or not. Everything was silent. So immediately we approached this court, status quo order was granted. That is on the facts of the case. Now, my first contention is that, Your Lordship, I've already supplied this book, Your Lordship.
Yes, yes.
At the motion stage, it was argued by my learned seniors that Section 7 was, a part of it was deleted, that the complaint does not be placed before the Darbar Hima. But the second part, which says opportunity to be heard, still remains. So, Your Lordship, I'd like to place why, because after the Act was framed in 2007, the rules also framed in 2010. I'll take Your Lordship to the rules.
first, what are the provision?
I'm taking your lordship to that.
When suspension is affected, now what provision is done?
Section 7.
Section 7.
The act is enclosed, your lordship, to my writ petition. Annexure 1. Annexure 1, page 28.
No, section 7.
Lordship.
Yes, 2007.
Because when the notification was issued on 18, there's not even a whisper regarding whether it was a suspension pending inquiry or not. That I'll refer to some other cases which has happened in other ilakas later, Lordship. Now, firstly, Lordship, when there's a complaint, under the rules, Lordship, of I'll take your Lordship to page 352, your Lordship, of this book, the blue color book. Your Lordship.
Yes.
I'll go, your Lordship, to number 3, amendment.
This contains what? The rules.
Your Lordship.
This is the rules.
Yes, the rules, your Lordship. There was a rule 1010, and there was an amendment to this, to the parent rule, your Lordship. That was in 2015.
Okay.
Kindly see, your Lordship, 3 page before what I have referred, your Lordship, 352.
This one. (2010) amended in.
Your Lordship.
2010 amended in 2015.
Your Lordship. First amendment.
Okay.
2nd July, notified on 2nd July 2015 and published in the Gazette on 2nd July.
That's okay.
Now I'll take to Rule 3, Lordship, page 352 of that book, Lord.
Rule 3.
Amendment of Rule 3.2 of the Rules 2010.
Yes.
Now I'll go, your Lordship, to the proviso.
Yes.
In the existing Rule 3.2, a new proviso shall be inserted with the following.
Yes.
Provided that any complaint against its aim or acting aim, or before any action is taken, should first be brought before the Darbar Hima for necessary discussion and decision, and such Darbar shall be convened and presided over by the Deputy CM or any member elected by the members present. Suppose put the situation by someone has some interest in it, but any member can be elected from the members who are present to preside over the complaints in a meeting in case of his absence. Now this proviso, your Lordship, has not been complied with because the complaint was directly entertained by the Executive Committee filed by respondent number 6. It might be a serious allegations, but once there is a statutory provision and one there exists a rules, it has to be complied. I'm not against inquiry, only after the statutory provisions are complied with, Your Lordship, then only I'm willing to face any kind of inquiry. Now, directly from a complaint and
Yes.
going to the fact end of the sentence, Your Lordship, in my humble submission, cannot be allowed. When the statute provides, it has to be complied. Statute does, it's not for violation. So firstly, 3.2 has never been complied with.
Yes.
Now secondly, Your Lordship, I'll take Your Lordship to Section 9 of the Act, Your Lordship. That is at page 29 of my writ petition. Or on the book also is there, Your Lordship.
Yes.
Section 9, Lordship. Now, Section 9, Your Lordship, is with regard to appointment of acting CM.
Yes.
Now, I'll go and read Your Lordship to 9.4. Section 9,
Yes.
subclause 4, Your Lordship.
Yes.
Where there is a change of incumbent on account of subsection 1, above there shall be proper taking and handing over of charge of the office properties duly recorded in writing between the predecessor and the successor incumbents in the presence of reliable witnesses. Now, second violation, Your Lordship, is that there has been no handing over, taking over. In view of the fact, Your Lordship is also aware that we were served with a copy on 19 morning and we had approached this Honorable Court on Monday morning itself. So the question of handing over, taking over does not arise. And Your Lordship was pleased to grant a status quo order. And their allegation is that we have taken over. In what way, in what manner, is not understood.
Yes.
That is the second violation of the statutory provisions. Thirdly, Lordship, now for appointment of an acting CM, there has to be a recommendation from a recognized clan. I'll read same section 9.2, Lordship. 9 subclause 2. No acting CM shall be appointed without the recommendation of the CM's clan through the CM Seng.
Yes.
We'll see how it's been amended. I'll come to that. Now, Your Lordship.
Yes.
3.1. Now I'll take Your Lordship to that book again at page the rules against Your Lordship 2010.
Yes, page.
In my book it's page 4, but it's before the acts or after the acts, after the principal act and the amendment. 22nd December 2011.
Yes, ma'am. Page 4.
Page 4.
In this book.
2011. This is the rule, Your Lordship. Has Your Lordship got it?
You had referred to page 352 later earlier.
I can assist Your Lordship. I can assist Your Lordship on this. Now this is the rules, Your Lordship. I'll take Your Lordship to second page, page 6. Qualification for the office of CM, acting CM or deputy CM. Rule 3.1.
3.1.
Rule 3.1, Your Lordship.
Yes.
Now I'll go to the next page, Your Lordship. The CM's clan eligible to nominate the CM, deputy CM, or acting CM of Langrin according to previous customs and tradition followed from ancient times are the Simyong clan, who are the descendants from the rightful womb of Karoin Simyong, Kalabon Simyong, Kasyang Simyong, and Kashuna Simyong, and the Simli clan, not the Langrin Simli. Now these are the 5 clans, Your Lordship, who can recommend. Now, Your Lordship, if Your Lordship peruse the affidavit filed by the District Council and the respondent number 6, it is found that it's not from this womb. It's what's that? Por. My Lordship, in the affidavit filed by respondent number 5 at page 12, it says affidavit filed by respondent number 5. Page 11, annexure A1. Filed on 29 August. Respondent number 5, Roger. R5.
Yes, we are referring to
page 11, annexure A1.
yes, annexure A1. Annexure 1.
Resolution, Your Lordship, dated 10/8/2023.
Yes.
The Darbar of Simyong clan, Porban Simyong, is one of the whom that can be appointed by as CM, Deputy CM, and Acting CM within Hima Langrin, and held a Darbar on 10 August 2023 at Mopansao, Langrin Simship. After detailed discussion with the clan members, we have taken one decision with our consent to elect so-and-so to be appointed as Acting CM of Langrin if the position of chief is lying vacant at that point of time. Now this Porpan does not figure in the rules. They are not the eligible clan to recommend CM or acting CM. So now my humble submission is that there has been a violation to the rule 3.1 of the 2000 rules.
Yes.
Now, one interesting aspect also, Your Lordship, is that I was suspended on 18 August. How is that on 10/8/2023? They are already aware that I will be suspended, so they already had a darbar to recommend somebody.
Yes.
This shows the malefied intention and the premeditated plans of the District Council and the respondent number 6.
Yes.
So this is a clear case whereby there is a collusion. How is that they've come to learn that before my removal, they already had a meeting and to recommend somebody?
Do they do that as a contingent measure?
Yes, yes. Even in the earlier occasion when he was suspended in the year 2017 also, the clan had written a letter to the executive committee informing them in case anyone, this CM is suspended, so and so should become the, even in the earlier occasion also.
How can it be?
It has
But
to be
still-
there because, my lord, once there is a suspension, somebody has to be appointed. Somebody has to be appointed to take his place. That's why that contingent is there.
But the rule says that it should be subsequent to the suspension. Then you hold the meeting or darbar or whatever the case may be.
I'll come to the rules because these rules, my friends are saying, those have all been amended.
You might say it's redundant and amended. I'll come to that, Your Lordship. That's why I'm sticking my submission this court today with regard whether statutory provisions have been
Exactly.
complied
We'll
or not.
look into that only.
Because that is a core issue.
Please continue.
Your Lordship.
I said, please continue.
Yes, I'm continuing, Your Lordship. Now, Your Lordship, next violation, Your Lordship. Before I go to that, I would like, before we go ahead, regarding that complaint placing before Darbar, Your Lordship, there's already a precedent by this court. And I've placed, Your Lordship, I'll place it again. Kindly see, Your Lordship, para 12.
It's not reported.
Reported, Your Lordship.
Where's the citation?
Para 12, Your Lordship.
Yeah, citation.
Where's the citation?
Citation is, Your Lordship. That I'll supply later because I've taken out. It's reported in NEJ and those Northeast journals, Your Lordship.
Yes.
Paragraph 12, Your Lordship. Paragraph 12, I'll read, Your Lordship.
Yes.
This court already stated above that construction of the statutory rule should be made in such a manner that every part of the rules and regulations should be given effect to, and a harmonious interpretation of the provision of the Act should be made so that no provision of the Act and rules should be redundant or surplus. In order to make Rule so-and-so of Rule 2026 effective, the Darbar Hima, which is going to consider the said complaint so-and-so filed by the respondent so-and-so, should not be presided by the Sardar or his relative, that is the Deputy Sardar, or by any one of the members of the Darbar Hima authorized by the District Council for this purpose. It is made clear that if the Darbar Hima requires the hearing of respondent number so and so while considering the complaint, the private so and so and also the petitioner may be heard. The Darbar Hima shall consider and decide the complaint within 3 months from the date of receipt of the certified copy of this judgment and order. It is also made clear that Executive Committee of the KHADC, Shillong, may take a decision deemed appropriate under Section 6 of the Act after receiving the decision and resolution of the Darbar Hima. Like I have submitted earlier, Your Lordship, that 3.2, it should be placed before the Darbar Hima, and any member who is a neutral member may be recommended to be a chairman and preside over the complaints. Now, depending on that, the member should submit a report to the District Council, and District Council, if it deems fit to take action, then can take action against me under Section 7 and suspend me pending inquiry, whatever. But this was never done as provided under the rules. So there's a precedent of this Honorable Court which still hold the fields till today, Lordship. Now we'll go, Your Lordship, to the affidavit filed by the respondent number 5. Because the affidavit filed by respondent number 5 and the affidavit filed by the district councils are more or less on the same lines, but number 5 is more elaborate.
Who is number 5?
Respondent number 5. The acting CM, the beneficiary of all this.
Okay.
Agenda. Now, Your Lordship, we'll go to paragraph 5 of the affidavit of respondent number 5.
Yes.
Now, we also admit that there was an amendment to some part that the complaint that has been deleted, but that has been brought about by the rules 3.2, which I have read, Your Lordship, and those rules have been published in the official gazette to make it public. That then, Your Lordship, I'll take Your Lordship where they say that the rules have been amended.
No, you are referring to paragraph 5. You have not read paragraph 5.
Paragraph 5, I say I admit that a portion of it has been deleted. That complaint.
What does it
Section 7, which I've read earlier, Your Lordship. Section 7, there was some portion has been deleted.
So paragraph 5 admitted.
Now, paragraph 10, Your Lordship, of the affidavit filed by respondent number 5. But even then, even though in the parent act has been deleted, but again in the rules, because the rules has come about because there was no powers, functions and duties prescribed to the CM how to go about. That is why rule 3.2 was brought about regarding placing the complaint before the Darbar. That is why the 2010 rules came in, and then it was amended 2015, and 3.2 proviso was added regarding the complaint to be placed before the Darbar. That I have already submitted and I have placed, Your Lordship. Now, paragraph 10 of the writ petition.
Writ petition or
Oh, sorry, Your Lordship. Paragraph 10 of the affidavit filed by respondent number 5. Page 6 of the affidavit.
Yes.
Here they say that the entire rules of 2010
You read out these.
and the amendment.
Read out these.
Your Lordship, okay. With regard to statement made in para 16 of the writ petition, the answering deponent denied the correctness of the same and further submits that requirement to submit a complaint to the Executive Darbar was part of the Principal Act 2007. However, realizing its mistake, the same was removed from the statute book by amending the Principal Act by the House of the District Council called Second Amendment of 2010. Further, the said requirement was not included in the rules 2010. Therefore, Proviso 3.2 of the amended rules of 2015 was also in contrary to the Principal Act, though the same was approved by the District Council in the form of the First Amendment of the rules 2015. It was approved by the District Council. It was published also in the Official Gazette, 2015 amendment. That means the insertion of 3.2. It is settled law that the rule cannot override the Act. Moreover,
There was no challenge to the virus of the.
They have not done that till now. I was about to come to that, Your Lordship. They have not challenged the virus of the rules till date. Moreover, 2015 rules was amended by 2019 rules, which was approved by the Executive Committee, wherein the requirement of submission of complaint to the Executive Darbar was amended and deleted. The above rules 2019 framed by the Executive Darbar of the same shape only requires approval from the Executive Committee of the respondent District Council and hence doesn't require publication in the Gazette since the same was not framed by the District Council under the 6th schedule, but the same was framed by the Executive Darbar of Ilaka. Though not admitted for the sake of argument, even if the above requirement still exists in the Rule 2015, still the same was appeared to be submitted directly to the Respondent Council by the complainant, having found no effective and efficacious remedy available before the Executive Darbar headed by the Deputy Chief, who functions under the direct control and supervision of the suspended petitioner. Therefore, the submission of the complaint to the respondent number District Council appears to be quite reasonable under the above peculiar facts and circumstances of the case. In any case, no prejudice can be caused to the petitioner for placing him under suspension pending inquiry. Now, in reply to that, Your Lordship, para 10. I'll take Your Lordship to my rejoinder. Rejoinder, Your Lordship, filed by me to the affidavit of the respondent number 5.
Affidavit in reply.
Affidavit in reply. Has Your Lordship got it?
Yes.
I'll take Your Lordship to paragraph 9 of the affidavit in reply. Para 9, Your Lordship. In reply to para 10 of respondent number 5 affidavit. Para 9, page 9.
Yes, please.
With regard to the statement and averments made in paragraph 10 of the affidavit in opposition, the deponent denies the same. The deponent begs to state that although the first proviso of section 7 was deleted by amendment in the year 2010, it is not intention of the legislature to take away the said proviso as stated by respondent number 5. The amendment that took place in the year 2010 was viewed the fact that duties and functions of the CM and Darbar as provided in the preamble was not provided. As such, in exercise of powers under section 11 of the KHAD's nomination and election of CM, Deputy CM, Headman of the Act of 2007 and 2010, rules were framed and approved by the Executive Committee of the District Council and duly published and notified in the Official Gazette of Meghalaya. Since the procedure to entertain any complaints were not provided in the Principal Act after its deletion, the Executive Darbar of Hima Langren, after thorough deliberation, decided to amend by adding the proviso of Rule 3.2, which provides as follows. Provided that I have already read that earlier, Lordship, that it has to be placed before the bar. It is pertinent to state herein that after the aforesaid amendment, the same was placed before the Executive Committee of the District Council, and after due deliberation by the Executive Committee of the District Council, the same was approved and accordingly published and notified in the Official Gazette on 2/7/2015. Now, Your Lordship, respondent number 5 says that the entire rules has been repealed because a new rule has come in 2019. How did 2019 rule came, which till date I'm functioning as the CM also is not been known to me? I'll explain, Your Lordship. I was suspended in 2018 in the month of December, where I've submitted earlier for 8 months I was out of office. Now, during that intervening period of 8 months, the acting CM at that point of time brought this resolution to amend. It was amended without the general public knowing it, and it was approved by the District Council.
Again, there was no challenge to that.
The question of challenge does not arise, Lordship, because the public are rely to some decisions. Because for every rules frame or amended, it should be known to the public and it should be published in the Official Gazette. This was kept with the District Council. Okay. Me, the functioning CM till date, not knowing that such rules have been repealed and a new rule has come into effect. That was done 2019, which in my humble submission, Your Lordship, a constitutional authority of which the District Council is exercising, is doing this kind of practice, keeping it in their pocket. Now after 2023, they say that has been repealed. They took out from the back pocket and placed it. And that rule has not been even placed by the District Council. It's been placed by the respondent number 6, who is a complainant. Now, why I'm saying is that the rule, if it has to be amended or repealed, it has to be published in the Official Gazette, which I rely on some decision, and the 6th schedule of the Constitution of India, which at paragraph 11, Your Lordship, of the Constitution. I'll take Your Lordship to the Constitution at 6th schedule, paragraph 11. Paragraph 11, Lordship. Take out those municipal rules. As the Lordship got it, para 11.
Yes.
Para 11, 3 lines only. Publication of laws, rules and regulation made under the schedule. All laws, rules and regulation made under the schedule by the District Council or Regional Council shall be published in the official gazette of the state and shall on such publications have the force of law.
Yes. Yes.
So, Your Lordship, the rules which Respondent number 5 and the District Council are relying that it has been repealed by 2019. Once it's not published in the official gazette, it has no force. It's redundant, Lordship. Now I'll cite some examples also, Your Lordship, which the District Council themselves only has written to the District Council Affairs for publication of those rules. Now, Your Lordship, this is an example. Now, science M-shape rules.
Yes.
It's the same. These rules were framed. It was published in the official gazette. Next one is the Williams M-shape rules. The rules were framed. It was published in the official gazette.
Yes.
Now they say that it's not necessary. District Council themselves are saying that it's not necessary. Whereas in other ilakas, they themselves are the one who get it published before the.
Yes.
So the rules which they're relying on, Lordship, in my humble submission, has no force of law.
Yes.
1951. This is a judgment, Your Lordship, Supreme Court in Harla versus State of Rajasthan, 1951, Lordship. I'll go take Your Lordship to page 3. Page 3, Lordship.
No paragraphs again.
The last paragraph, Your Lordship. We do not know the laws.
Yes.
On the 6th line, Your Lordship, 6th line.
Yes.
Natural justice requires.
Yes.
I'll read, Your Lordship. Natural justice requires that before a law can become operative, it must be promulgated or published. It must be broadcast in some recognizable way so that all men may know what it is. Or, at the very least, there must be some special rule or regulation or customary channel by or through which such knowledge can be acquired with the exercise of due and reasonable diligence. That though that a decision reached in the secret recesses of a chamber to which the public have no access and to which even their accredited representatives have no access, of which they can normally know nothing, can nevertheless affect their lives, liberty and property by mere passing of the resolution without anything more is abhorrent to civilized man. It shocks his conscience. In the absence, therefore, of any rule or regulation or custom, we hold that a law cannot come into being in this way. Promulgation of public or publication of some reasonable sort is essential. Why I'm saying, Lordship, the rules which this relying saying does not require publication because it is framed by the Darbar Hima and only the District Council. And that too is not made known to me nor the general public. I am serving as a CM till now. I have not been known about that. That was done during that 8 months period when that acting CM was. And
Yes. What is this?
Lordship, this is Supreme Court again, 2008, para 28,
Is it Supreme
29.
Court? This is Allahabad High Court.
Allahabad High Court, Your Lordship. Para 28, 29 and 30. In state of Jharkhand versus Ambe Cement.
Just a
So sorry, Your Lordship. Para 28.
Yes.
In state of Jharkhand versus Ambe Cement 2005, Volume 1, SCC 368. In para 26 of the judgment, the court held, it is the cardinal rule of interpretation that where a statute provides that a particular thing should be done, it should be done in the manner prescribed and not in other way. Which I've omitted earlier, Lordship, there is a violation of the rules. When the rules prescribe that it should be placed before the Darbar, it has to be done. It should be done in the manner prescribed and not in any other way. 29, Your Lordship. Not only the government in the present case has declined its approval or has not granted prior sanction as contemplated under Section 42. But it is also an admitted fact that no publication in official gazette has been made till date for amending Rule Regulation 12 of the Staff Regulation insofar as it prescribed the age of superannuation of Class 1 and Class 2 employees at the age of 58. The effect of non-publication of the official gazette where the statute requires has also been considered by the division bench in which one of us so-and-so was a member of the judgment dated passed in so-and-so Lordship. It held, we have in no manner doubt that the 1970 regulation could have been amended only when the impugned amendment 1998 would have been published in the official gazette and not otherwise. Admittedly, the same has not been published in the official gazette. The result is that 1970 regulation continue to operate in the same manner and in the same form which they were on date when the impugned amendment 98 was prepared by the respondent. And the impugned amendment 98 at the best can be said to be a draft agreement of the regulation. But in the absence of publication of the official gazette, it did not bring any change or alteration of the 1970. That means, in my case, the 2015 rules amended and the 2010 will still hold the field, Your Lordship. 30, Lordship. Where the statute requires publication in official gazette, it has been held to be mandatory and failure of publication on official gazette cannot be taken lightly. Effect could be given only when provision is made and published in official gazette. In BK Srinivasan versus State of Karnataka 1987, 1 SCC 658, considering the importance of publication in official gazette, the apex court held. It is therefore necessary that subordinate legislation, in order to take effect, must be published or promulgated in the same suitable manner, whether such publication or promulgation is prescribed by parent statute or not. It will then take effect from the date of such publication or promulgation. Whether the parent statute provides the mode of publication or promulgation that mode must be followed. This I've read again, Your Lordship, which this judgment has been relied, Supreme Court judgment in Srinivasan, paragraph 15. This judgment has been relied by the Allahabad High Court.
Yes.
I will...
Not necessary to read it again.
Not necessary. Now, one more provision, Your Lordship, which has not been complied with of the 15. Now, Your Lordship, very interestingly, the rules which they're relying 2019, which was never published, that has been annexed by the respondent, the Seng Samla respondent number 6. I'll take to that affidavit, Your Lordship. The affidavit filed by respondent number 6. The rules have been annexed by the respondent number 6, the complainant. Page 7, Your Lordship.
This one.
Page 7, Your Lordship.
Page 7, Annexure. Yes. Annexure A.
Annexure A. Dated 1st February 2019.
Yes. Yes.
This was done during the time I was under suspension, Your Lordship. I was suspended on 21st December before Christmas, before the vacations. And this rule came to be approved so fast, that is on 1st of February 2019. It says, with reference subject above, I am directed to inform you that the Executive Committee KHADC has, as empowered under Section 11 of the Khasi Hills Autonomous District Nomination and Election of CM, Deputy CM, Headman of Langrin Section Act, approved the administration of Langrin Revised Rule 2019, which was passed by the Executive Darbar, Langrin's Emship, as conveyed by your letter dated 22/1/2019. So 22/1, there was Executive Darbar of that acting CM, and on 1 February, after a week, it was approved. That also, even after it was approved, it was never made public, not without our knowledge, not about the people of Langrin's Emship, who are the subjects. No one has been known about this. It has come out now only after my suspension. Now it says Executive Darbar, Langrin's Emship, the last line, Your Lordship.
Yes.
Now I'll take Your Lordship to the 2015 rules against Your Lordship. Page 370, towards the end, Your Lordship. Page 370.
Yes.
The amendment of Rule 11 of Rules 2010.
This is rule. This is the 2015 rule.
Yes, the amendment.
Yes.
Now it says, the existing rule 11 of Rule 2010. A new Rule 11A shall be inserted with the following, namely 11A. 1. Any provision of the Act and rules framed thereunder shall be amended on a decision and written resolution of the Darbar Hima. Now it says Darbar Hima, but the rule which they have amended was only by the Executive Darbar. So this is another ground whereby there is a statutory violation by the respondents herein.
Yes.
Now I'll take Your Lordship, I'm drawing an analogy as to how the suspension order has come about.
How long will you take, Mr.
Because I'm only on the statutory provision, Lordship. I'm not on merit. So on statutory, only one more ground is left, as has been done in other cases. I'll just take Your Lordship to very fast. Two things I like to bring, Lordship. It's important to place this, Your Lordship, that is at page 38 of my affidavit in reply, Your Lordship.
In reply to what?
Affidavit in reply to the affidavit in position filed by respondent number 5. Page 38 of my affidavit in reply.
Yes.
Here, Your Lordship, after when I was reinstated again in 2019, in the month of August, I have written this letter to the District Council. With reference to subject cited above, I undersigned would inform you that Executive Darbar of Hima Langren has come to the knowledge that the acting CM, Bolwesta Sim Yong, was since been removed from his office on 13 August 2019, had tried to bring about amendments to the administration of Langren's MShip Rules 2010. I am also to inform you that the first amendment of the said rules carried out in the year 2015 by the Executive Darbar, and till date no other changes, amendment to the said rules have been brought about. As such, I am to inform you that the Executive Darbar has come to the knowledge that Sri Bolwesta Sim Yong had tried to amend the rules while he was the acting CM in the year 2018-19. As such, I hereby inform you that the Darbar of Hima, which was held on 2nd December 2021, unanimously and decided to reject the changes to the said rules, which was made during the time of the acting CM. As such, he had acted without the knowledge and consent of the ministries or elders of the Hima who are the permanent members of Hima Langren. Therefore, I request, the undersigned humbly requests Good Office to instantly reject the changes amendment with regard to the rules. This, after that was done, we have taken the decision also, Your Lordship, to reject such amendment.
Earlier you said you have no knowledge. Earlier you said you have no knowledge of this amendment.
Yes, Your Lordship. That was earlier when we came to learn about it. We have written to them.
You said even today you have not.
I said that, Your Lordship. I will not deny that. But this letter which I have read, we have informed the District Council. Even though, Your Lordship.
So as on December 2021, you know.
We knew. 21. But even though it was not published, my primary contention is that, Lordship, these are periphery arguments, Lordship.
It's your integrity that is in question.
Your Lordship?
It's your integrity that is in question.
Your Lordship, I apologize, Lordship. Your Lordship, another analogy I would like to draw is like Annexure 3 of page 35 of my affidavit in reply.
Yes.
This is with regard to non-port citizenship. Here it says, Your Lordship, because my suspension order, no reflection about suspension pending inquiry. And there's no reflection of any order pass. Here, in a similar case, this is to notify the entire Ilaka Citizenship that Executive Committee, Khasi Hills Autonomous District, White Order dated 11/4/2023.
Page 35.
Page 36, Lordship. 35 is the Khasi version.
Page 36.
Here, what I'm trying to say is that the suspension order has been reflected in the notification.
Yes.
Whereas in my suspension, Your Lordship, where I have brought by an additional affidavit, there's no mention about any order being passed, which goes to show that it's an afterthought just to oust me from my office on the basis of those complaints. So finally, my final argument is that the suspension order which was pending inquiry that was provided to me, Your Lordship, I've placed that on record by way of additional affidavit. Kindly read the order, Your Lordship. It's a 2-paragraph. It's a non-speaking order. It's passed in a very mechanical way without discussing my show cause. They just say like, no, we are not happy with the show cause. That is why we are suspending it. So in view thereof what I have submitted, Your Lordship, whatever the statute that has been provided, that has not been complied with. If it would have been complied with, Your Lordship, I am ready to face any kind of inquiry. Firstly, that has to overcome, then only if any report comes, anything against me from the Darbar, because even the complainant also, they have to face the Darbar Hima. What is the complaint all about? Because there are only few number of them. You have to look at the entire population of Langren. They also will have to face, I am ready to face. Then any report that comes therein, that follow thereafter, I am ready to face any kind of consequence, Lordship. So my only submission is that statutory provision has been complied with. And I pray that the impugn notification suspension order may be set aside and quashed.
We will continue.
We'll continue. No, because my submissions also is only in the law point. What are statutory rules? This is very important. That's why I've been telling the District Council that before they make any rules or amend any act, they should consult legal experts. Because here the question is, what are statutory rules? It would appear that I'll make my arguments.
Yes. The issue of publication in the Gazette.
Yes.
You have to overcome that.
No. First of all, we have to understand what are statutory rules. Now, Executive Committee has no power to make any rules. That's as per the Constitution 1951 and also as per Para 3. Executive Committee is not empowered to make rules at all. It's only the executive functions. So, I'll reply.
When do we continue?
At 2, my lord, if it's...
Not today. Today because I have a
all right.
meeting.
My lord, tomorrow also, tomorrow and the after, I'm a little...
I thought we'll continue tomorrow.
Lordship, next week also, 18, 19, 20, I have some family obligations. 18, 19, 20.
Day after
21st or on Friday?
Friday, my lord.
Not on a Friday.
Not Friday, my lord, Monday.
Not on Friday because Friday I may have to leave early.
Monday or Tuesday also because I wouldn't take a long time.
Nobody is not free on those.
I'm not free, Lordship. I have some on 21, Your Lordship.
Yes, my lord.
21.
Just let me check the board.
There's no doubt a very interesting issue has come up for decision by this court. Although the main issue has been brushed aside.
Yes,
suspension.
It'll be interesting.
Yes.
So we'll have it on 21st. But Mr. P. Nogri, counsel for the petitioner. Matter has been partly heard. As submitted by the parties, list this matter for a hearing on 21st.
Right.